Hello, everyone, and welcome again to our Ethics Matters lecture series. I'm very happy to introduce today a colleague, a friend, Maitre Fadi Moghaizel, who is a Lebanese attorney and member of the Beirut Bar Association since 1985. Maitre Moghaizel is currently senior partner of Moghaizel Law Office, a firm of 21 attorneys founded in 1953. He has a licence en droit from the Faculty of Law from Saint Joseph University in 1985, an LLM from the University of London in 1986, and a PhD from the University of London in 1991. He was admitted to the Beirut Bar and started practicing law in 1985, and has also been admitted to the Paris Bar in 1991. His main areas of practice include arbitration, litigation, contract laws, medical malpractice, medical and healthcare law, and commercial law. Maitre Moghaizel is also a colleague at the Medical Center Ethics Committee at AUBMC and the University Legal Council since 1998. And we are very happy to have him with us today. Maitre Moghaizel will be talking to us about a very important issue in Lebanon that has recently been declared in the legal official gazette, if I may say, which is the new official release of the Lebanese Medical Ethics Code. Maitre Moghaizel will talk about the new releases, so not about the old Lebanese Code of Medical Ethics. And most importantly, I have received emails from a lot of colleagues asking whether we have an English translation of the Lebanese Code of Medical Ethics. And Maitre Moghaizel kindly gave us a translation of the Lebanese Code of Medical Ethics, at least of the new one. And you can find it by logging to the Salim Bioethics and Professionalism website. If you go to the Ethics Matters section, to Public Lectures, 2012-2013, you will find the series of Ethics Matters lectures that were given this year. Of course, we have not yet uploaded Maitre Moghaizel's lecture. It will be uploaded as soon as possible. You will have his lecture. He gave us his PowerPoint presentation, in addition to the newly revised Lebanese Code of Medical Ethics in Arabic and in English. So please join me in welcoming Maitre Moghaizel to.
Thank you, Dr. Arrawi. Thank you for the attendance. I will, before starting going through the slides, the PowerPoint presentation, which in fact reproduces the new provisions of the code. I would like to say that I would like to go back to the title of the code, of the talk, please. I said a small step forward. I would like to say first that the law is undeniably a step forward. First, it has clarified several issues that were not detailed in the old law, and it has also regulated and elaborated others such as CME, continuing medical education, clinical research, organ donation and transplantation, assisted reproductive technology, and stem cells. Even though I should say that normally those issues do not have their place in the Code of Ethics. They normally have their place in specific separate laws, as is the case in France. So it is a step forward. It is, however, small from my perspective, because as you will see, several unnecessary and even unfortunate provisions have either remained or have been added. And I believe that 18 years after the enactment of the old law, in 1994, this revision was a golden opportunity to clarify several issues, such as, for example, the right to withdraw treatment as opposed to just withholding treatment in case of terminal illness, the ranking of family members when a decision has to be taken for unconscious or incapable patients, competition restrictions between physicians, telemedicine, and also especially establishing advanced directives. this opportunity, the opportunity to address such issues, was unfortunately missed. In my review of the revised law, I have noticed two prevailing trends. First, as it's happening all over the world, an increased importance of the patient's freedom to decide. The patient is really becoming more and more, if I may say, the boss. And the second issue is reinforced powers of the Order of Physicians. The approval of the Order of Physicians has been introduced in many areas, as you will see. Before starting running the PowerPoint presentation, just four points to mention. First, I wish to highlight the relevance of French law. I know this is a US institution, but and most of you, or a lot of you, have a US background, or some have studied in the US, but Lebanese law is based on French law. And this also applies to the present code, which follows to a large extent the form and the substance of French Code of Medical Ethics. Historically, our first Code of Medical Ethics of 1969 was based on the French Code of 1955. Then we had the second code, which you know, the 1994 Code of Medical Ethics, which followed the succeeding French laws. We are discussing today the third generation of the Lebanese Code of Medical Ethics, which is also inspired by the French law. Now, I call the code the new code. It is not entirely a new code. It is the revised 1994 code. But there have been so many amendments that I think it's right to call it the new Lebanese Code of Medical Ethics. The second remark is that I have assumed that most of you have some knowledge of the old code. It's a matter of time, because otherwise I would have to set out the rules contained in the old law, and then it would require much more time. However, for specific issues, important issues, I will quote the old provisions for the sake of comparison. Third, I have outlined the changes that I have considered more relevant than others. So due again to time constraints, my presentation leaves out some changes. For instance, the duty to inform the Order of Physician of any illegal practice of medicine, the obligation to use the order's stamped forms, access to medical records, etc. Lastly, just referring to the translation that is going to be on the site already. It's a translation made by a translator of the Arabic text, so it's more or less a literal translation. I have reviewed it and approved it, but the text that you will see here is more simplified. I have simplified it more for the sake of clarification. I will start with the first topic, because the articles, the article is just for convenience, so that you know where you find the provisions. So I called it the patient's sovereign will. Already in the 1994 law, the patient had an increasing role in decisions relating to medical care. In the 1969 law, it was not addressed in a clear way. In the 1994 law, it said the patient's will must be respected as much as possible. This is the old law. Now, as you see, it says the patient's will, and I have added freedom to decide, must be respected, and whatever is underlined and bold is the new text, so you can compare with the old text. Here, it's in every medical procedure. It's not as much as possible anymore. And if it's impossible to obtain the patient's consent, the physician must obtain the consent of the patient's family, starting from the first degree, and I will come back to that, or the consent of the person of trust designated in writing by the patient. Person of trust, you might know that in the 2004 law on informed consent, this concept has been introduced where the patient can designate a person of trust, as is the case in French law. Now, the person of trust gives an opinion, and the physician takes it into account. It is the physician does not have to follow. It is not mandatory. So the person of trust says, I would like to do that or not to do that. The physician will have to take it into consideration. This is in the informed consent law. Here, we are talking about the consent of the person of trust. So the law gave him or gave her a more important role, not just an opinion. I want to go back to the family. And I think you might encounter this several times because there might be disputes among family members. So the family, they say here, the family is starting from the first degree. First degree means the wife and the children. And then you go to the parents. This is the cell. Then you go to the brothers and sisters, etc. Unfortunately, they have not defined the order among those first degree members. And this was really, it's very important. And I'm sure in your practice you agree that this is important because you might have the wife says something, the eldest son or daughter says something, then another child says something else. So there's no indication. However, it is not that bad in that in a separate law, which is the decree regarding organ transplants, which does not apply here, but it can be a source of inspiration. It says the following, I'm translating from the Arabic. It says that the order is as follows. First, the spouse, wife or husband, and so she or he decides. Then, in absent a spouse, the children, starting from the eldest children, and thanks God they have not made a difference between female and males. So it's the al-walad al-akbar. Even though in some Arabic countries, walad is only the boy, but in Lebanon it's either a boy or a girl. So al-walad al-akbar sinnan, and then al-asghar fal-asghar, then the younger, etc. Now, if there are no spouse or children, then here, unfortunately, it's the father only, then the mother. So the mother comes second, which is not the case in French law, for instance, and I'm sure in the US. So there is an order. This order is not the one that has to be applied here by law, but you can certainly use it as a source of inspiration in case there is a dispute. And of course, it's always good to consult with the university's council in this case. Okay, I'm going now to the continuing medical education. Continuing medical education has been introduced in the law organizing the two orders of physicians, the one in Beirut, which covers all of Lebanon except Tripoli and the north, and the order of the north. So it has been introduced in 2002, or 2002, 2003. In 2008, the order of physicians has laid down the mechanics for the CME, for the continuing medical education, how it operates, how it functions, etc. Now, what is important here is that for the first time, continuing medical education has become mandatory. And you can read here that a physician must keep acquiring continuing medical education in order to develop her knowledge and technical skills, etc., etc. So, and of course, in accordance with the CME program adopted by the Order of Physicians. And to really underline the importance of this obligation, you can read then, if a physician fails to fulfill such obligation, the Order of Physicians must take disciplinary measures and report such failure to public insurance institutions, which is something serious. So CME has become an obligation, and an obligation that is sanctioned, which is quite important. Now, the equipment of the clinic, if you go to number 2, and by the way, when there is 1 and then no 2 in a following paragraph, it's not my mistake. This is how it is in the law. Sometimes they put 1, then there's a paragraph without 2, then there is a 2. So some small defects of, so the defects of form in numbering reflects the law's numbering. Now, what they have added for the clinical equipment is that they said here, first it was the physician who had to decide. Now they say that the sanitary and technical conditions at the end for the equipment of medical clinics are determined by the Ministry of Public Health after consulting with the two orders of physicians in Lebanon. As you will see, several matters have been reported or transferred to the orders of physicians for determination, to the Ministry of Health, and unfortunately to decrees, implementing decrees. And as we all know, it takes years in Lebanon to issue implementing decrees. So you will see for several topics, the law says what should be done, and then it says the mechanics, the details, etc., will be included in decrees by the cabinet after consultation with both orders of physicians. So you can imagine it's a matter of years. You'll see that later. Passing to Article 7, death certificates. What's new here is that they say a physician must, in case of the death of a patient, issue a death certificate, which includes, they have specified what should be included in it, which was not the case in the old law. And what's new also is that if the death takes place at home or not in a hospital, the physician must report the fact to the appropriate authorities. In practice, it's to the police. It's easier. They want to have the opportunity to make sure that the death did not result from any offense or crime or suspicious conditions. What's new also is that if the physician cannot identify the cause of death, then she must or he must request from the parents an autopsy examination. Now, this is not mandatory. The parents can say no. And this fact is recorded, as you say, on the death certificate, meaning that he has asked them and they said they refused. Okay, reporting mistreatments. Here there's an important change. The new text says that when a physician notices in the course of her professional practice or his professional practice that an incapacitated person or a minor was the victim of abusive confinement, mistreatment, deprivation, rape, or sexual assault, she must report such fact to the appropriate authorities. So that's quite important, and I mean, it's important to inform the community, the physicians community of this requirement, and also the medical staff, because the medical staff will alert the physician, and the physician then will have to report to the appropriate authorities through the hospital's administration. Here I have added a note because initially the text said, there was a text saying that the physician had to report any alcoholic patient or drug addict who refused to be treated and who are dangerous to others. So this or is important. So here again, the increasing importance, the increasing predominance of the freedom of the patient. So alcoholic patients, there's no longer any obligation to report them. For drug addicts, I say here, reporting drug addicts who are dangerous to others, not just the fact that they are drug addicts. So there's one condition. If you are treating a drug addict when you feel that he or she might be dangerous to others, then they must be reported. It's in a different law. It's in fact in the law of 1988 that concerns drug addicts and that concerns the use of drugs, in fact. Okay, I'm going now to a point that's of interest to physicians exclusively. The physicians, as you know, the 1994 law has introduced the principle of the fasl al-at'ab, as we call it in Arabic, fasl al-at'ab, the separation of fees. This new Article 8 has added more details, prescribing separate invoices and asking insurance organizations to pay the fees directly, and asking, they say, a patient or the patient's agent or representative to the contract. This is how it is in Arabic, fi al-aqd al-muta'aqid. So it means the patient must pay the fees directly to such physician. No advertising and publicity. I mean, you know that this was the case in the old law. However, there are two things. First, the old law, there were no programs like the doctors or similar programs at that time, or maybe we were not aware of them in this country. Probably they were, but not in Lebanon. So the only prohibition then in the old law was that physicians had to refuse to appear, they say zuhur, in articles that are published in the press. So it's just articles published in the press and that are addressed to the public, because they considered it was some sort of publicity. Now it has been changed completely because there have been developments and an evolution, and they say very clearly that a physician may not take part in any educational professional activities, and this, I think, very directly refers to those programs on TV, in any press or audiovisual media, without at least a 3-day prior notice registered in the registry of the Order of Physicians. So, and then they add that the physician must restrict himself to or herself to medical data that is scientifically documented, etc. And he must also be cautious and attentive to the influence of her statements on public opinion. So here they have modernized. This is one of the provisions that's useful, that is a plus, and that is one of the components of this step forward. Paragraph 2, a physician may participate in public scientific debates upon prior notice to the board of the Order of Physicians. Again, the Order of Physicians' role has been really increased in nearly all avenues. Still no advertising and publicity. I will go on this very quickly. I think you know them, but they were not specified as such in the old law. No direct or indirect advertising. And then, you know, this number 4, which was applied in practice, that a physician may only announce for 1 week that he is starting or she is starting medical practice, relocation, and the date of her travel. So it has been organized in the law. Number 5, a physician may not make any direct or indirect publicity, whether in his own interest or in the interest of the institution in which he belongs or where she works or in which he owns a share. Again, more clearer restrictions that existed but were not implemented maybe very strictly because they were not clear enough. It's much clearer now. Forced treatment. Forced treatment in the event a mentally retarded person, I'm sorry, it's in the Arabic text, they say متخلف عقليا, so it's not my term. They still use mentally retarded person, and this is one of the opportunities that has been missed. This is in the old law. They should have at least changed this term. What they have done is that they have only removed, and in the note between brackets, an injured person has been removed. And again, this is in the context of strengthening the freedom of the patient, the patient's right to decide. The patient, between quotes, is the boss. So in the event a mentally retarded patient refuses the proposed treatments, again, her relatives, what does it mean? Unfortunately, they should have say family of first degree with a specific order. It could have been done at the end in one article saying when we refer to family of first degree, it is 1, 2, 3, 4. An easy step that has not been taken. So her relatives or legal representative, as well as the physician, are allowed to dispense with her prior consent. This is the same. The law was, this is how it was before, so only the underlined and bold has been changed. If a patient suffers from insanity or dementia or is a danger to others, a physician must ensure the possible medical care to him in a hospital. I must say that before that, in the old law, there was something called administrative restraint, الحجز الإداري. So you could just gather 3 specialists, physicians. They would say that this person must be restrained, and the person would be restrained in the hospital or in the institution. This has been cancelled because it might be a source of abuse. So clearly, now there is a mechanism here. You can do without the consent if the family agrees, but the hospital administration must notify the health or judicial authorities. So Ministry of Health and the public prosecutor, المدعي العام. So there is some control on what's going on. You cannot just lock in someone because 3 physicians said that he should be locked in. Okay, we're passing now to a very important topic for all of us, I think, which is euthanasia and terminal illness. I'm going to start with the old text down in italics. The old text says, it is paragraph 10, and now it's paragraph 11, so the number has changed because they have added the paragraph in this article 27. So if a patient suffers from a disease, this is the old law, with no hope of recovery, the physician's mission shall be limited to reducing his or her physical and mental pain and giving her the appropriate treatments for protecting as much as possible her life. So the importance of palliative care has already been introduced by the old law, and it's still in, and this is, of course, something that's very satisfactory, importance of palliative care. Now, then you had in the old law the physician, the physician alone, one physician, may not willfully put an end to the patient's life, of course, and it's better not to have recourse to technical means and to excessive treatment to prolong the duration of the agony. In the old law, it was ihtidar. And it remains necessary to support the patient until the end in such a manner that preserves the patient's dignity. Now, this article has been divided in two. It starts, a physician may not put an end to the patient's life due to compassion. Good. Even if the patient asks him or her to do so. And then they add, a euthanasia, which means euthanasia. The sentence is not very well drafted, but it's a general prohibition of euthanasia. So far, so good. Then they say, if a patient suffers from a disease with no hope of recovery, this was the old text already, the physician's mission will be limited to reducing his or her physical and mental pain, palliative care, and give him or her the appropriate treatments for protecting as much as possible her life. Now, it's better not to have recourse to technical means and to excessive treatment. This is fine. With the consent of the parents, this is fine. And what is new here is, and according to a joint report by the treating physician and the head of the department concerned. I will talk about this, then come back to the matter of withholding treatment. So they have introduced in the law the concept of collegial decision from the French code, décision collégiale. The physician alone can no longer decide that we're not going to resuscitate, or we're not going to apply this or that measure because it is futile and the conditions apply. Now, and the French code prescribed for this collegial, collective decision, 2 physicians or even 3 physicians in the French code. The drafter of this article have adopted the principle, which is not the physician alone, but you must have a consulting physician, but they have provided that the consulting physician is the head of the department. In the French code, it is explicitly said that the other physician must not in any case be a physician which has some moral or legal authority on the physician, because otherwise there will be no neutral decision-making process. I do not know what was the idea behind this. By adding the head of the department concerned, it would have been very easy to say by a consulting or a consultant physician. This has not been done. It is quite unfortunate because the physician and the head of the department, I don't know to which extent they would like to issue conflicting opinions, knowing the relationship between them, etc., etc. So this was one of the unfortunate additions that was made. Now, going back to the issue of withholding treatment or withdrawing treatment, and this because we have had these cases so many times as counsels to this institution, receiving questions, can we withdraw the BiPAP? Can we withdraw this or this equipment? Can we stop giving this medicine or this treatment? The problem is that they have revised the law, and instead of saying that of clarifying the fact that you could either withdraw or withhold, was not clarified. So it is still withhold. So we still have the same issue. It is still that it's better not to have recourse. It's still withhold. So it's still withholding treatment, not administering the treatment. So if someone is a terminal illness in a situation where it's completely futile and it's excessive treatment to add a treatment, either artificial respiration, BiPAP, etc., with the mechanism of decision, with the head of the department, with the family, etc., you can decide not to do that, then this is fine within the conditions. However, if he's already on BiPAP, already on the treatment, we're in the same square where we were like 20 years ago. No one can take the decision of withdrawing whatever you could withdraw or of stopping a treatment. And this is, from my perspective, really a big miss here. lastly, there's the issue here of directives, of advanced directives, sorry, because in the French they call them directives anticipées. Advanced directives. Advanced directives exist in the French law. They have been there for like more than 10, 20 years, 10 15 years. The difference with the US system is that in France they are not mandatory. It is like the person of trust. You can just take them, the physician has to take them into consideration. Here too, I do not understand why this has not been introduced. So this is also really something that should have been introduced, advanced directives. Okay, very quickly, anesthetist obligations. The anesthetist first had to take the information from the treating physician and then to, before preparing the patient. Now they have added two things. He has to, or she has to examine the patient. She has to examine the patient and review the medical file. This was not the case. First, you had just to rely on the treating physician or attending physician by obtaining from the surgeon, as they say here, useful information. And so three new obligations: examining the patient in person, reviewing the medical file, and recording all the information in the medical file. So these are new obligations for anesthetists. Medical records, this has Article 29, judicial and health authorities, as well as the order of physicians, again, more power to the order, may obtain a copy of medical files which are the subject of complaints and investigations. Initially, the order had to obtain the approval of the patient. And when we used to receive requests, our advice was also to university, even if it's the order of physician, you need a waiver of the secrecy from the patient. Now this has been overcome, which is not a bad thing, because it facilitates the formalities. So now the order of physicians no longer needs to have the patient's approval. It is assumed that when there is a complaint by the patient, impliedly there is this authorization. Now keeping medical files for 10 years, okay, this is, I think, a secondary issue. Now, there are three topics here: human experiments and clinical research, organs donation and transplantation, assisted reproductive technology, in fact, four topics, and then the stem cells. I will go very quickly. Time does not allow to go through to the details. So they have inserted in those four topics, which generally must be treated and handled and addressed in separate laws, they have added everything here. And so you will see for human experiments, okay, these are the conditions. You can read them later. Again, continue the conditions. Then, number two, the thing I mentioned at the start, the implementing legislation, they say the formation of the ethics committees, follow-up of medical research, clinical experiments in hospitals, tasks, objectives, principle, methods, control shall be determined by a decree issued by the Cabinet upon proposal of the Minister of Public Health. So this will require time, and in the meantime, we will have a legal vacuum. The same for organs donation and transplantation, which is covered by another decree, but at the end of this law, it's said that whatever is in contradiction with this law is repealed. So here, again, the conditions are added. The trade of human organs is forbidden. This was the only sentence in the old law. All the rest has been added. Again, at the end of paragraph 4, after obtaining written consent from the family of the first degree, in which order, we don't know. The last paragraph, they mentioned a Lebanese National Committee for Organ and Tissues Donation and Transplantation. Again, here, the removal from the body, the consent of the Lebanese committee, in accordance with conditions and principles determined by decrees issued by the Cabinet, upon the proposal of the Minister of Public Health, plus after consulting with the two orders of physicians, which is fine, but it's more time. Okay, you can read the conditions again. Again, the last paragraph is that the applied methods, etc., by decree, by the Cabinet, etc. Now, assisted reproductive technology. there was only one sentence in the old law, which is number 6, artificial insemination or pregnancy through assisted reproductive technology may be used for spouses upon the written consent. That was the text. Then I'll go to number 7, number 8. Again, they say that all the implementing mechanics will be specified by decree. There's an important issue here that they added, and this is one of the additions that I also qualified or characterized as unfortunate. They added in number 6, subject to the applicable laws of the civil, Muslim, Christian, and religious courts. First, the religious courts do not have laws. They do not have laws. You either have a law or court decisions. So the sentence as such is wrong. And second, there are no laws, no religious laws on these issues. There are positions. For instance, the Catholic Church is the most extremist. It refuses all sorts of artificial insemination because for the Catholic Church, having sex is only for procreation, and you can only conceive children through sexual relations. So Catholic Church, all is forbidden, and it is because you have one authority, which is the Pope, it's clearly forbidden. The Orthodox Church, they don't have a Pope, they have patriarch, but they follow more or less the Catholics in that opinion. The Protestants are open to all sorts of artificial insemination or pregnancy, etc. For the Muslim religion, for Muslims, it is allowed with one caveat, is that the third donors third-party donors are not approved by all the fatwas, if you want. It has to be, the donor has to be the husband. It has to be, of course, a married couple. For the Jews, it's the same. So adding this sentence really doesn't add anything. It's just going to complicate the life of the physician and the patient because there's nothing you can do. What can you say? If you're a Catholic, you go and you get a paper that you cannot do it. Anyhow, in practice, it's not going to be followed, I think. And okay, now very quickly, disfigurement in cases of emergency. The text is the same. They just added what is in bold. Again, family of the first degree, who they are, what order, we don't know. Number 10, the surgeon alone may decide during an urgent treatment to perform a surgery leading to disfigurement, provided he obtains the patient's consent, if he is aware, or the written consent of the family of the first degree. So it's just that the consent has to be in writing now. Now, the very important and new introduction, which again should have been provided for in another law, are stem cells. Stem cells. So they have provided for stem cells culture techniques, 4 conditions, scientific research, university medical center licensed by the Ministry of Public Health, medical ethics committee must give its consent, patient or the patient's representative must give his written consent, etc. Again, unfortunately, at the end, the techniques, the possibility, conditions, preservation, disposal, must be determined by decree, etc., etc. So, which means waiting for a few months or maybe years. The medical committee, the changes are underlined. They just clarified that the medical committee should also take care of scientific and moral issues and the physician's right to professional fees. This was not provided before. And here, the election of the medical committee now is under the supervision of the order of physician. Again, the increasing role of the order of physician. They have added that the various categories of physicians must be represented, and they have given in 5 a greater role for the committee in the matter of fees and in the matter of resolving conflicts between physicians. So now when there are conflicts between physicians and when there are conflicts between physicians and the hospital administration, the medical committee has been given a role to try probably and find a solution amicably before this goes to court or to the order of physicians. Very quickly, premarital tests and driving license test. Now it's necessary to have a driving license and for marriage to have a to issue, to have a medical test undertaken. They have just laid down a mechanism in specific forms, so I don't think this is vital. Disputes between physicians. This is new because first, when a physician had a dispute with another physician, he or she could just inform the order of physician and sue. Now, a physician cannot sue another physician without the permission of the order of physicians, of the orders board. So if a physician is going to sue another physician, he or she goes to the order, submits an application, and then within 1 month of the registration, there must be a decision, yes or no. To facilitate things, if there is no decision, in case of silence, the permission is deemed as implicitly granted. Here I have put the old text, which was initially you just had to inform the president of the board. Still just 3 or 4 slides. Common fund. For the common fund, they had just clarified that it's managed by the medical committee with the cooperation of the hospital administration. The two last items, the patient's freedom of consultation. Okay, now how to go back to the, sorry, because there are 2 slides. Okay. All right, so patient's freedom of consultation. Again, the patient has more and more decision power. If you go to point 2, if the patient is willing to leave her initial physician, he has to, or she has to record the appointment of the new physician, and the initial physician must provide the new physician with all the information. Before, the previous text was that the new physician had to ask the patient to inform the initial physician first. Now, I mean, this is not required anymore. If the patient wants to consult a physician other than the treating physician, treating meaning attending, this latter must meet, MU, must meet her request, and the consulting physician must leave her colleague the result of his diagnosis, etc. Initially, it was that the new physician has to propose, to suggest to the attending physician to carry out the consultation jointly. So now again, no, the new physician alone, and it is for the patient to decide. The last thing is that if the patient wishes to consult a physician, then other than the treating physician, this has to be met, etc. And okay, I have seen this. I have talked about this. The last point, okay, Article 54. So here, the first paragraph is the same. In the event of disagreement between the various physicians, the treating physician must inform the patient of all the opinions, and the patient or the representative, etc., must decide in writing who will continue the treatment. Before that, the text said, in case of disagreement, the treating physician had the right to withdraw. في حال الاختلاف يحق للطبيب المعالج الانسحاب إذا رجح رأي الأطباء الآخرين. So now it's the patient decides. He is informed and the patient decides. The last thing is that Article 55, the patient may request again the opinion of a consulting physician with the approval of the treating physician. And if the treating physician does not agree, the patient decides. So this also is very important because first it was completely the contrary. It used to say that the consulting physician is not entitled to examine again the patient in the absence of the treating or attending physician or in case of his objection. خلال فترة المرض. It used to say in Arabic لا يحق للطبيب المستشار العودة ثانية لعيادة المريض بغياب الطبيب المعالج أو عند عدم موافقته وذلك خلال فترة المرض. So they have changed it completely. So again, this is the end of this is the trend of the increasing role of the patient. This is I've exceeded my time and apologize, but thank you very much.
Thank you, Matt. Very helpful overview. Regarding forced treatment, what do they mean by insanity? I'm assuming they mean those patients who do not have the mental capacity to make informed decisions due to their psychiatric conditions. Is this what they mean by insanity?
Yes, I mean, again, unfortunately, as many of the terms used in this law, there is no statutory definition, no definition by the law. So you have to go to the medical definition, really, which probably
there's no medical definition for insanity.
Or if you want the definition that is used in the field, and the one you just quoted seems me to be reasonable, I think.
Is there an article that covers those who are at risk to harm themselves rather than at risk to harm others?
Yes, I mean, the forced treatment, again, there was an overreaching article for people who are either drug addicts or are alcoholic patients who used to fall in this situation. Now it is only for people who cannot decide for themselves. And as you let me
the
go.
article specified if they're at risk to harm others.
Let me go back.
And they may be at risk to harm themselves without using drugs or alcohol. They may just,
of course,
be suicidal.
Of course. To themselves, there's nothing here. It's mainly to others. To themselves, unfortunately.
يمكن ورا شوي.
ايه ورا. هيك اهين بالكيبورد. Okay, in the event a mentally retarded, مرجعنا على قصة mentally retarded, the definition is prehistoric. Mentally retarded person refuses the proposed treatment. Yes, you can dispense with her consent. Okay, this is one thing. If a patient suffers from insanity or dementia, and is a danger to others, so they say or. So, okay. So in fact, yes, you can even with the or. I don't know if they really thought about it, but so even if it's not a danger to the others,
the physician must ensure possible
medical care to him
in a hospital. Does this mean against the patient's will?
No, you cannot force. What you do, in fact, is they added this sentence. You advise the administration. The administration calls the mudda'i am and ask or write to him, telling him, look, there is this person who is a danger to others. Do we force him? Because it must ensure. I mean, it's not clear that you can force. It's not clearly stated that you can force them. And then the mudda'i am, the public prosecutor, will issue a two-liner. He can do it on the spot. Say, okay, you can, even verbally, he can say it. You keep him in. I mean, force him. Issue an order to keep him in or keep her in. So you cannot alone decide that they should be retained or restrained or kept in. Yes,
without
yes,
mudda'i
yes, yes.
Thank you. I mean, لأنه حاطين or, you can argue that insanity's definition may cover those who are at risk to themselves due to a psychiatric condition.
Yes, but it says the physician must ensure the possible medical care. The possible medical care, does it mean that you are entitled to force him not to leave the institution? And
this can be part of medical care.
It can, I mean, you have to interpret the law, yes, yeah, but it's safer. It's certainly safer to call us, and we call this can be done in a few hours. To call the mudda'i am, and then he will tell us what to do. I mean, the mudda'i am you can through the police station. He can be called at any time. He will not be happy to be awakened at night, but you can. Yes, you can. Sorry, I just read the Arabic. على الطبيب تأمين العناية الطبية الممكنة له. ممكنة له. يعني you cannot force him.
Thank you again for sharing with us the new changes. Could you comment again on the DNR issue and do not resuscitate and terminally ill and that situation with where you need two physicians, including the chairman or the head of the department?
Okay.
How it's applicable here for us at AUB?
All right. Now, DNR is taken in this institution from the American system. DNRs are not known in French civil law system. DNR do not resuscitate. They fall in the context in France of the Directive Anticipée, advanced directive, which means that if that situation occurs, do not take measures. So it's within that general context. So that's why we can say it is valid. It is more or less valid under, it is valid, not more or less, it is valid under Lebanese law in that general context. So this is, even if advanced directives are not recognized here, but still it is an expression of the will of the patient.
Do you need to have two physicians?
No.
Or one physician can just write DNR
no,
and
that's the issue now. Is
because
that
we often see those orders on the charts, and
now with the new law, with this introduction of the collective decision-making mechanism, where you have to have a joint opinion with the head of the department, the DNR, which is considered as part of a general will or instructions or will of the patient and the family not to resuscitate, not to take a specific measure, a positive specific measure, falls within the general framework of this provision, which means that yes, from now on, or from mid-last November, the physician alone cannot decide.
So they have to include a head of a division or a head of a department.
They have to consult him. I mean, I assume this can be made on the phone. I mean, taken on the phone.
Signatures on the chart?
Yes, you will need two signatures. Otherwise, you will be in
I think this
breach
needs
of
to
the
be
law.
clarified for the in our policy here to really clarify how this
Yeah, I
has
mean,
to be
many
reapplied.
changes will have to be implemented.
We discussed this during the Medical Center Ethics Committee, and I think with the Office of Accreditation, we will be revising the policies and procedures, and we will be hearing something about this. Yes.
Thank you, Maitre. I would like to ask any new additions on brain death diagnosis, disease donation in this particular new edition of
The
law?
brain death is still defined in a specific statute, which is well organized.
It is 3 physicians now.
It is 3 physicians, and there's a whole. There are
Criteria,
objective
yes,
criteria, and this
So
is
they
working
are out
fine.
according to the
It's still the same. It's working fine. To determine whether a person is brain dead, there's no change here.
Fine.
Now, for organ donations, it has been clarified here with the mechanism, but they have said they have provided for some conditions, but implementing them will be set out in a decree.
But there is a contradiction between the law and you cannot withdraw the ventilator and organ donation. When you take the patient to the organ donation and the operating room and you are done with the retrieval, you just unplug the respirator.
No, if he is brain dead, you can unplug, because legally brain dead is dead.
Specifically in brain death condition, you can withdraw the...
It says that when a person is brain dead, he is considered as dead.
Can you issue a death certificate?
So,
you cannot issue a death certificate.
No, but what happens is that when you remove those equipment, it's a matter of probably a few days,
but
then you
if
issue
you
it.
have a brain death still on the ventilator,
No, still on the
unit,
activator you cannot.
You cannot.
But you can remove because he is dead. This is the difference.
A death certificate.
You cannot issue for a few days. I mean, if he's brain dead and no more respirators,
No, we
how
have
long?
brain death persons for 1 year now.
Without any support?
With the support. Of
La,
course.
I'm
You cannot withdraw the support.
If
It
he is
doesn't
brain
allow
dead,
you.
if he is brain dead, he's considered as dead, along to the criteria. So in that instance, you can withdraw, only in this specific instance.
Only in organ donation instance.
No, only when there's a brain death.
Even on the unit.
When there's a brain death, the law says that this person is considered legally as dead. فخلص بتشيل فنتليتر وبتدفنيه.
This is the new edition.
No, البرين ديد من كل عمرها هيك. برين ديد كل عمرها هيك البرين ديد. هلا العائلة بتقول لك لا اخليه بضل. اوكي.
لا مش كوماتوز اكيد بقى.
لا بس الكرايتيريا كثير
I will look, I will read it.
Okay,
and
but the
if
brain
have
death
specific
definition, the
questions, I
criteria
will-
are very strict. I mean.
إيه عم بقول له بدي اقراهم and if I have extra questions.
Sure.
I will.
My pleasure. Thank you.